So, yesterday we discussed about what the law of persons all about. So, yeah, and the various philosophical questions associated with that. We discussed that persons, what laws are for. Okay, laws are addressed to persons, and they are the units of analysis, as you have seen in Hofel's jural analysis. Okay, so they are the units of analysis, and they are defined as the ones who are capable of bearing rights as well as duties. So the more restricted idea person says that they have to be capable of holding both rights and duties, whereas the more wider definition that we looked at, approach that we looked at, is the one that says that merely capable of having rights, or law recognizing them as having rights would be enough for us to say consider them as persons. We also looked at persons in law being of two different kinds. Okay, one that is natural person, and humans come under that. Humans, by virtue of being born alive, come within that category of natural persons. And then, as opposed to that, law also by fiction, by legal fiction, recognizes personality over non-human entities. Okay, and we have examples of juristic persons. I mean, like corporates, joint what we call as corporate personality, like companies, joint stock companies. Then you have idols, municipal corporations, etc. And we also discussed about how the idea of personality is to be understood. Okay, and that it can be understood not only from the legal perspective. That's not sufficient. We have to be conscious of the moral dimensions, the moral questions that are consciously or otherwise, okay, may have already made their way into our legal understanding of this idea of persons. So that's what we have done, and we also discussed about how this idea of persons might be understood and be relevant in the future, especially in the context of developments in artificial intelligence. And that's what we have discussed. And one more thing that I forgot is that persons to be understood as opposed to property. The persons are the ones who bear the rights, okay? Whereas not so much not the case with respect to property. So today we are going to take up certain specific. Okay, we also looked at different definitions of persons, but that can be understood in the light of the overall discussion of persons. Okay, so today we are going to talk about certain specific cases of legal status of humans. Now, I'm using the word legal status. Okay, what's the reason? The reason is that we discussed yesterday that sometimes personality is recognized. Okay, one may be recognized as a person, but not all benefits that arise out of recognition of personality would be available to all at all time. So the legal status would vary, okay, from one person to another. Certain rights might be recognized, certain rights may not be recognized, okay. So the totality, that bundle of rights can be considered as the legal status there. Now, there is not much confusion when it comes to the differences in the different kinds of rights that are held by people who are born alive, okay? But the problems arise when the people who are dead or who are not born yet, okay? That's where the legal problems, okay, and the jurisprudential problems, arise and become relevant for us, and we need to have a discussion about that. So The general idea is that you're considered as person when you are born alive. Okay, so your legal personality status starts at your birth if you're born alive and ends at your death. That's the general understanding, because you are to be you are a natural person because you are born alive. However, there are other situations where certain status, okay, if not the status of legal person, but then certain other rights, if you may call it, okay, or interest, if you may call it, are protected. Okay, so that's what we are going to discuss today. We'll start with legal status of one who is dead. Okay, I'm not going to use the word person, but I might end up using here and there. Okay, but because the law says that, as we understand, the personality starts at birth if one is born alive and ends at death. Okay, so that's the time during which we can consider one, okay, as legal person. But certain status, okay, certain rights are protected. Okay, even before one is born and once after one is dead. So that's what we are going to look at. So today we are going to look at, as I just told you, legal status of one who is dead, a human who is dead. Okay, so the personality of a human, the general understanding is that the personality of a human being starts at birth and ceases to exist at death. Okay, so that will mean that a dead human has no legal personality. That's the idea. Okay, now this pretty much fits into our understanding of rights from will theory perspective, if you look at it. Okay, and how is that? If you remember from our recent discussions on will and interest theory, will theory says that holding rights makes you a small scale sovereign. You are autonomous being, okay, capable of making choices, autonomous choices. You're capable of deciding for yourself. That's the idea, okay? So rights are understood as one's power or capacity of claiming it, okay? And also that also means that you can also waive it, as will theory says, okay? Which becomes important, okay, and which is also one of the defects of the will theory, as we discussed. But here it's important. Why is the will theory important here? The idea that your personality starts at birth and ceases at death is based on that idea. If you notice here, it's because once you were born, you're a conscious being, okay. You're able to make choice. However, not so much though, as you can see, a child who is merely born will not be able to exercise that much choice. But let's assume that that understanding is there, that one who is born alive, okay, and is not dead yet, rights are recognized. So you may say that will theory allows, with certain exceptions, this idea of personality of one who is born alive and not dead yet. Then that would mean, okay, now that would mean that a dead human being has no legal personality, because a dead human cannot make those autonomous choices, as will theory would say. So will theory would say that, well, a dead human being has no legal personality. So what would be the implication of that? We discussed that being a person would mean that having rights and also duties. Okay, so once a human dies, okay, they lose all their rights. Okay, that's the understanding. They lose all their rights. Why is that? Will theory would say that because they can no longer make those choices, okay, regarding their rights. As opposed to this, we have another theory of rights, if you remember, the interest theory. That becomes relevant for us. So one may say that, well, why does one lose personality once he or she is dead? From interest perspective, one may say that that's because they lose all their interests. Well, then one might also question, really, do our interests end with our death? if you're taking an extremely practical, pragmatic view, one might say that yes, obviously the person no longer exists, not conscious, will not be hurt, will not be affected. So the person who is dead, the human who is dead has no interest. But there is another way that we can say that, well, interest exists. Okay, one may say that, well, interest does not exist. Why interest does not exist? Because that person no longer has the knowledge that the interests are being affected. It's that, not capable of knowing, feeling. But others might say that, well, it's not always necessary under the law that one should have the knowledge of their interest being affected for their interest to be protected. Okay, that's also the case, as we have discussed. Okay, so will theory, you see at this stage that will theory does not allow for one to be recognized as having any status after that. Whereas if we look at it from the interest perspective, okay, we see that, well, there is a possibility of certain rights being recognized, because those are certain interests which may be protected, as we will look in the in our discussion. So just like the way we understood rights, it's all the more clear when we talk about duties. Okay, it's all the more clear when we talk about duties. You may say that, well, rights protect interests. So even after one is dead, there may be certain interests which are protected, and hence protection of rights. But does it make sense to say that someone who is dead, have duties? Well, the burdens might, pass on. Okay, burdens go with the property. Okay, encumbrances go with the property, as we discussed. That's with the property, isn't it? But does it make sense to say that one who is dead have duties? So just like they don't have rights, if you go by the strict, will theory. So more appropriate would be in the case of duty that they are also immune from, or they do not have duties. Okay, they do not have duties. Because if you consider someone as having duties, and if they do not fulfill those duties, then certain sanctioning rights become irrelevant, if you remember from our discussions earlier. But here, those sanctions would make no sense. So it does not make much sense to say that the one who is dead have duties. Okay? Even with respect to that, so the other theory, that is interest theory, becomes relevant. Okay, because the interest theory would emphasize more on the interest. Okay, so that becomes relevant for us. However, that's the general understanding. Okay, that's the general understanding that your personality starts at your birth and ends at death. Okay, so we have many examples of situations, okay, where the law interferes with respect to certain matters relating to a dead human being. Okay, maybe not in the strict sense of rights as we understand, okay, but certain interests. That's why the interest theory, that I had emphasized earlier, is important for us. Okay, let's look at certain example, okay, where certain interests are protected, and how are those interests protected. So what kind of interest may one have? Okay, as a living being, I have an interest in my body. Okay, I have an interest in my reputation, and I have an interest in my estate, my property. So these are the interests that I may have. Now, once I'm dead, I do not have any interest in my body. Okay, I do not have any interest in my body. I do not exist. I'm. That's the end of me. Okay, you may say that certain interests after I'm dead, okay, are protected of those. Okay, my descendants. Okay, my descendants. Okay, they might have certain interest in my body. I'm not talking in terms of property. But certain other interests might be there, and there might also be certain societal interest. So those are definitely protected. So for example, one who is dead is entitled to a decent burial. When I say entitled, I'm using it in a broad sense. Okay. So decent burial is something that is, done. Now, in such case, is it the interest of the one who is dead, or is it the interest of those who are living that is protected? It doesn't make much sense to say that it's the interest of the dead who is protected. If you are talking about it in an extremely materialistic sense, the dead is gone, okay? But if you do not talk in that materialistic sense of the world, then you might say that even after one's death, they have an interest in their body being disposed of properly, okay? So that's the understanding. So the idea is that your body is not to be treated as your property once you are dead. Okay, so it will not be disposed of like the way your property would be disposed of. So you cannot make will about how your property is, how your body is to be disposed of. So your corpse is not your property, and hence you cannot make a will as to how it is to be disposed of. But you nonetheless have a right to a decent burial, which is protected by criminal law, as you will see. So for example, section 297 of IPC makes desecration of graves an offense. But in such case, whose interest that is being protected here? You see, it's not so much the interest of the one, who's dead. More so is the interest of the society or the individual. So that's one of the defects that we had looked at, we had found in the interest theory of rights, okay? Sometimes one might have rights, but the interest lies somewhere else, okay? So that the interest theory is not capable of explaining. So here it seems that, well, an interest is being protected, and that interest does not belong in the one who is dead because it's dead, okay? The interest is someone else's, okay? Or that is of the society and of the individual. Then does it make sense to say that the right belongs in the one who's dead? Well, you have to just stretch your understanding, okay? Stretch your explanation here to say so. Now that's the idea. One more thing that becomes... Yes.
So I have a doubt. So when people sign contracts or agreements saying that after they are dead, they are donating this part of the body, that part of the body, then does that not come under this definition?
It's not contract, okay? It's not contract, it's not agreement, okay? So you can do one thing, okay? You can register with this, organization, okay? What's the name of it? I forgot, okay? This. You can register there, okay? That I want to sign up as a donor of my organs. That you can do. But does it have any legal effect? Well, in India, not so much, okay? Because once you are dead, it has to be your family members who has to give the consent. So before you die, if you donate don't take it otherwise, okay? We all die sooner or later. So before we die, if we make such organ donation, so you will be assigned a card, okay, that will say that, well, you are an organ donor, okay, prospective organ donor once you are dead. But that in itself does not create any, legal effect, okay. So in such case, once you are dead, your family members have to, give consent to that, okay, only then. So you see, even in this example, you see whose interest are we really concerned about? The one who is dead or the ones who are living? See that another example of case where
the ones
who are living what's being protected. So does it make sense to say that, well, it's the right of the one who's dead? So that's the rule in India, okay? So even if you donate your organ and you have a card, okay, in such case it's very much legal, okay? You can do that, but it does not take any binding legal effect. That will be only after, because once you are dead, it will be up to your relatives to basically consent in such matter. Okay, so that's what happens when it comes to organ donation. And so, as I was trying to explain to you, interest theory helps, but not so much, because it's not really the interest of the one who is dead, but of those who are living that is being protected. Okay, because if it were the interest of the one who is dead, then it should have a binding, legal, effect. But that's not what really is. Anyway, but interest theory, helps us in understanding why these laws exist, okay, and how these interests are protected. So that's with respect to your body, okay. That's what with respect the law is with respect to your body, or jurisprudentially, as we can understand the legal status of dead human when it comes to their body. The next situation would be with respect to reputation. Okay, it's said that a dead person's, sorry, again I'm using, so please bear with me, huh? When I say dead person, I'm using the word person in a very broad, lay sense. I mean dead human being, okay, dead human. So we are so used to using the word, persons, and that's why I've been using it. So I should warn you. So when a person, when a person is dead, okay, when a human being is dead, law provides another protection. That is the protection of their reputation, even after they're dead. Okay, the protection is from libelous attack. Okay. Now, as you will see in section 499 of Indian Penal Code that deals with defamation, it goes like this. Okay, I will read it out slowly as you will understand. You will have to look at explanation 1 to section 499 IPC as well. So section 499 IPC says, whoever by words, either spoken or intended to be read, or by signs, or by visible representation, makes or publishes any imputation concerning any person intending to harm, or knowing or having reason to believe that such imputation will harm the reputation of such person, is said to accept in cases hereinafter accepted to defame. So it's basically harming someone's reputation. But we said that, well, you can commit crime only against those who are living. What about those who are dead? So explanation 1 deals with that. Okay, so explanation 1 to section 499 IPC says, it may amount to defamation to impute anything to a deceased person if the imputation would harm the reputation of that person if living, and is intended to be hurtful to the feelings of his family or other near relatives. So the explanation, the defamation part is clear, okay? The definition is clear, and you will study it in more detail when you study IPC. We are concerned with the explanation here. It says, it may amount to defamation if to impute anything to a deceased person. So someone who is dead. The word is deceased person, so person again is being used in the broad sense here, okay? If the imputation would harm the reputation of that person if living, okay? So whether it would constitute, as a harm to the reputation of the person if they were living. That's the test, okay? That's the test of defamation. It's not saying that, well, it has to be only when it is the person is living, not that, okay? And is intended to be hurtful to the, so here's the part, is intended to be hurtful to the feelings of his family or his near relatives. So the remarks are such that if that person were living, it will hurt them personally. But now, okay, that person is no longer there. So is intended to be hurtful to the feelings of, his family or other near relatives. So for example, one might allude that, well, that person who is dead had an illicit affair with so-and-so, and his offsprings are like from that illicit affair. Okay. Something like that could be said. Definitely it harms the reputation of that person if they were living, and it is also intended to be hurtful to the feelings of families or other near relatives. Obviously the definition is subject to other defenses of truth, etc. Okay, so not concerned about that. But if it were a defamatory statement, okay, fulfilling all the requirements of this act, you see, it's also intended to be hurtful to the feelings of the family and near relatives. So in such case, it will be considered as an act of defamation. But the rule is that defamation, it should be against, someone who is living. So in this particular case, why do we need this explanation there? Well, you see, so this explanation gives us certain pointers here. So is it the reputation of the one who is dead that is being protected, or of the ones who are living, who are related, who are family members, whose interests are being protected? The explanation itself says that it seems to be the case that it's the interest of those who are living, is the one are the ones that are being protected. So yeah, hence does it make sense then to say that the one who's dead has a right? Well, one might say so, but one has to stretch it, okay, and then say so. So maybe the dead individual has interest, okay. Then you may say that one may ask you, how is it possible for the dead to have any interest in whatsoever? Being dead is equal to not being in existence. So how one who is not in existence could have any interest? Then you could say that, well, that person, if were alive, would have an interest, okay? And it wouldn't be necessary for that person to know that their interest is being affected for the interest to be protected. So if that's the case, then why can't we say that their interest is being protected even after they're dead? You can stretch and then say that as well. But you see that there is a question of interest, but the explanation here also alludes to the fact that it's the interest of those who are alive and who will be hurt by such, defamatory remarks, and that's the one that is being protected. So I will leave it up to you whether you want to call it right of the one who is dead. You can stretch and then say, but in reality, it's really the interest of those who are living that's being protected. Okay? So you can say that law doesn't really, in true sense of the term, protect the dead person from being, dead human being from being liable against, okay, but protects the living descendants. So that's what it is when it comes to reputation. Now, with respect to reputation, there is another thing which is not so much developed in India, but definitely is the case, okay, elsewhere, that I think you should also know. It's the idea of post-mortem right of publicity, okay, or you can say posthumous right of publicity. So your right of publicity after you are dead, okay, after you are dead. What is this? So it's possible for you, we could be celebrities, okay, we could become very famous, and we ourselves become a brand, okay. Then there could be trademarks created. So if trademarks are created, then you have statutory protection under the law relating to trademarks. That's there, not much of confusion. And then if you are a very reputed person, like and you not just ordinary reputed person, you're what do you call it? For example, if you were Mahatma Gandhi or Jawaharlal Nehru, then the statutory law protects your figure, your depiction of your figure, and that's protected under the statutory law. I forgot the exact name of the statute, but it's protected. So remember that Mont Blanc pen tried to use Mahatma Gandhi's image. So that's there, okay. So but we are not one such great personality whose images are protected under the law. But it is possible that if you reach some level of celebrityship, once you are dead, and while you are dead, obviously your right to right to privacy under Article 21 definitely provides you protection, constitutional protection, as was also held in Puttaswamy's case. But when you are dead, what about that? Okay. So in India, we do not have any statutory protection in such sense. Okay, if you become a celebrity, your name, your image could be exploited by companies to make profit. Okay, in such case, could you have some protection? Well, in the United States, although it's not in every state, in certain states, for example, California, etc. Okay, you have a post-mortem right to publicity, that your name's not misused for what do you call it, for the benefit by others, okay, for material or pecuniary benefits by others. So you have a right which is protected. Now, even in that case, whose right is it really being protected? You may say that, well, it's really the right of the ones who's being protected. Or you may also say that, well, it's really the rights of the descendants, okay, whose rights are being really protected. But then the same understanding could also be, as we discussed in the previous case, could also be applied to that. Now the next one, okay, next matter with respect to which it becomes a concern is with respect to estate, with respect to property. So what rights, okay, what power I'm using right in the general sense, not in the Hohelian sense, okay. So what right do those who die, may have with respect to their property? You become non-existent after you are dead, okay. What does that mean? You end, okay, and your interests and your, everything ends. It comes to an end. So that's very important. So along with that, your property rights also come to an end, and then your property devolves into successors, your heirs, etc. Now, however, there are certain situations where even after you are dead, okay, your interests seem to be protected. And examples of that would be testamentary, succession, okay, testamentary dispositions. So those will be the case. Not intestate, not intestate succession, because when you die intestate, then your personal law takes into effect, okay. In India, the personal laws take into effect, and then you can clearly say that it's the rights of those who are living, okay, living heirs, okay, whose rights are really being protected. But it becomes more clear when it comes to testamentary succession or testamentary disposition of property, okay. So when you dispose of property while you are alive, but it takes effect, okay, it's not really disposition while you are alive. So you intend what is to be done with your property, okay, when you are alive, but it takes into effect, okay, once you are dead. So that happens through will. So will is the example of the same, okay. So the law provides extensive power in the Hohelian sense, okay, to regulate by will how one's property is to be disposed of or enjoyed once that person is dead. Obviously, it's a case of will, okay. Obviously, this is not unlimited, or sometimes it's restricted by the law that is applicable to you, but law nonetheless, gives you the power to dispose of property, okay, while you are alive, okay. That is to take effect only after you are dead. So that's through will. Now the question arises, in such situation, whose interests are really being protected? Is it the interest of the one who is dead or the ones who are alive? Well, let's look at one law that will clarify, okay. So Indian Succession Act defines, okay, testamentary succession, that is will, succession by will, okay. So it provides that will means the legal declaration of the intention of a person with respect to his property, which he desires to take effect. As I said, okay, it has to take effect after his death, okay. It takes effect only after his death, okay. So that's testamentary succession. Now, see, the thing is, it does not take effect during the person's life. And if you remember earlier, I told you that the person in whose favor, certain interest might be created through the, will, does not have even a contingent right. Obviously, no vested right. And such a person merely has space succession, chances of succession. So that makes it clear that no interests are created while the person is alive. Fine, because if any such interests are created, transfer of property allows transfer inter vivos. So those techniques, those methods will be used. But if it is to take effect after one's death, okay, whose interest is it really being protected? You may say that, well, it's the interest of the person who is dead that certain property devolves into someone else, someone specific, okay, is being given effect to, and hence is the right of that person, that individual who is dead, whose right is being protected. But you can as much say, okay, with much more cogency, okay, that it is really the interest of the ones in whom the property is to devolve is the one which is being, protected. So in a pragmatic sense and not in a romantic sense, it makes sense to believe the later and not the former. Okay, so it seems that it gives you the impression that certain rights are definitely protected of the person who's dead, because the will gives effect to the wishes and desires of the one who's dead. Okay, the other person would not get the right if the wishes and desires were not there in the first place in the will. So that gives us the impression that, well, certain interest of the ones who's dead are being protected. Okay, but in reality, in practice, once the individual is dead, it's really the interest now of the ones in whom the property devolves, okay, is the one which is being protected. So again, another example of interest being protected. But confusion is with respect to whose interest, and whose interest is really being protected is something that we are dealing with. So you can then again, by stretching, you can say that, well, some interest of the one who's dead is being protected. But if you look at it, it seems that, well, it's really the interest of the one who are alive, okay, in whom the interest has been created, is the one which is being protected. So these are the situations, okay, these are the cases in which there might be others, okay, but these are the major ones in which we get this impression that certain status, okay, of the one who is dead is recognized. But even then, when you say that certain legal status is there, you still do not say that they are persons. Okay, that's something we do not use, at least not in the legal sense. You've seen that in 499 the word person has been used, but even there it has been used in the general sense, not in the strict legal sense. So that's the legal status of individual, human being who's dead. Okay, so am I making sense? Did you guys get what I was trying to explain?
Yes, sir.
Okay. Okay then. Others, just one. The others, I hope it's clear.
Yes, sir.
Okay. So yeah, if that's clear, then I will start just one more topic then. Okay. And deal with it in greater detail tomorrow. So I told you that personality starts at birth and ends at death. So we discussed about personality or legal status of one who is dead. What about one who is not born yet? Okay, so an unborn person. Now, unborn person can be understood in two different ways. Okay, so a child who is in the mother's womb, also known as child unwanted here, I don't know how to pronounce it and properly, pronounce it. It's unwanted samir. Okay, now I don't know if it's French or something. Let me check. So known as child unwanted samir. Okay, so maybe it's French. So I don't know, I'm not good at it. It must be something like this, something like that. Okay, so it means what? A child who's in the mother's womb. Okay, so I will use in the English sense. Okay, so
Right.
Yeah.
Can you type in that?
Oh, yeah. Just a second. Yeah, the expression is like this: child unwanted samir. Okay, I don't know how to pronounce it in French. Okay, so it has to be something like I don't know, 23 samir. That's how, I don't know. I'm making fool of myself here. Whatever, but in English we call it unwanted samir. Okay. So yeah, what does it mean? It means in the mother's womb. Okay, in the mother's womb. So a child who's in the mother's womb. So there are two ways in which one can be unborn. Okay, one who is in the mother's womb but not born yet, and the other one would be one who does not even exist in the mother's womb. So one who has not yet been conceived. Okay, and the law determines their legal status accordingly. So the more and more rights are recognized as the process progresses. Okay, so fewer rights are recognized if one is not even in the mother's womb, but then from your taught paper, I'm quite sure that in certain cases, even those who are not even conceived, but if their parents were exposed to some harmful chemicals, and because of that they were born with certain genetic defects, in such case, in many cases, even their rights have been recognized, okay, of being born with a healthy body, whatever. Now there are jurisprudential questions with respect to that, terminologies that we will discuss, okay. But yeah, rights have been recognized even in those situations. Now, and more rights are recognized once unborn person is conceived, okay, but person again is being used in a broad general sense. But then fewer rights at the moment of conception, if you even want to call it, okay, and then more and more, as it becomes more and more viable, and obviously complete person, once he or she or they are born, okay. So that's what the general idea is. So certain rights are recognized, okay. So with respect to child who is not even conceived, one who is not yet conceived, very few rights, but yeah, we have cases of such rights being recognized. And then once conceived, obviously fewer rights compared to those who are born alive, but protected nonetheless. And then as the baby becomes more and more viable, much more interests are protected, okay. So, and there you have this entire debate relating to bodily autonomy versus life, this conservative versus liberal debate that you have. I'm not sure if any one of you got that as a project, but I will just introduce the debate to you. So that's there. And obviously once one is dead, once one is born alive, much more rights are recognized, at least in theory. You're considered as persons and considered as having all the rights of that you get by virtue of being born alive, okay, as a human, all the natural rights, all other rights that you get by virtue of being born in a particular legal system, you become entitled to that. So that's how it works. So yeah, we will in the next classes, okay, in the next class, discuss about the status of child in the womb of her mother, okay, and also the ones who are not even conceived. A few cases here and there will illustrate that, okay, especially when it comes to law of tort. There it becomes much more relevant for us. So one thing that we can start with, though, okay, they are not recognized as complete person, as living human, living human beings, okay, who are born alive, okay. So they are not complete person in that sense, okay, in the legal sense of the term, but they do have certain rights that are protected, and that's where all these moral debates emerge, okay. And rights quite often are in conflict, okay. If you consider them as one who is conceived in the mother and is in the mother's womb as persons, then you will say that, well, they have a right, and then what about the right and autonomy of the mother? So you have this entire debate relating to abortion. So I think in those situations we have to look at the matter in a very scientific manner. Let's see, we will discuss about this when we come take up those specific topics, okay. So that's where I'm going to end my discussion for today. So in the next class we are going to look at the legal status, okay, legal status of one who is conceived and is in the mother's womb. First we will look at the ideas generally, and then we will look at those specific debates that we have. And that's it from me for today.